Oyez. All persons having business with this, the Honorable Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now in session pursuant to adjournment. Chief Justice Nicholas Matry presiding. To his left, Associate Justice Keith White, Associate Justice Thomas Yee, Associate Justice Amir Barini, Associate Justice Carlos Alvarez. To his right, Jeffrey Swartz, Associate Justice Associate Justice Jeffrey Swartz, Associate Justice Byron Longworth, and Associate Justice Justin Sublime. You may be seated.
Supreme Court of the United States is Connor Quickdraw versus the State of Cooley. Petitioners, would you please rise and state your name?
My name is Katerina Savrakis. That's K-A-T-E-R-I-N-A. Savrakis, S-T-A-V-R-A-K-I-S.
My name is Brianna Washington. That's B-R-E-O-N-N-A. Washington, W-A-S-H-I-N-G-T-O-N.
And respondents, would you please rise and state your name?
My name is Susan Lee, S-U-S-A-N-L-E-E.
My name is Kimberly Lewis, K-I-M-B-E-R-L-Y, L-E-W-I-S.
Thank you. Petitioners, you may approach the podium and begin.
Good afternoon, Chief Justice, Your Honors. May it please the Court. My name is Katerina Savrakis, and along with my co-counsel, Brianna Washington, we will be representing Connor Quickdraw, the petitioner in this case. I will be addressing that the search of room 123B was not justified on newfound suspicion, and my co-counsel will be addressing that the search of the box underneath the bed violated the petitioner's privacy interests under the Fourth Amendment.
Why was the search not justified?
Excuse me?
Why was the search underneath the bed or into the room wasn't justified?
I will get to that point, Your Honor. May I reserve 2 minutes for rebuttal? The search was not justified for 3 specific reasons. First, there is a lack of a search warrant. Second, in one's castle, there is a heightened expectation of privacy. And third, there was a lack of consent in the search. In Weeks v. United States, this court held that evidence derived from an unreasonable search and seizure is inadmissible in the federal courts because excluding such evidence was the only way to vindicate rights that are guaranteed by the Fourth Amendment. In Maryland v. Garrison,
Was that
1987.
really the purpose of the exclusionary rule?
Excuse me?
Was that really the purpose of the exclusionary rule?
To deter police misconduct?
Yeah, that's not what you said. You said it was somehow it was the only way to solve the problem somebody had.
Yes, Your Honor, I apologize. The exclusionary rule does serve to deter police misconduct.
What was the police misconduct here?
In comparison to our case in Maryland v. Garrison, officers had a search warrant for an apartment. After searching 2 rooms.
We're not looking for what happened in another case. I believe the Associate Justice's question was, why in this case?
What happened here? I mean, what did the police do wrong here? In 2 sentences, tell me what the police did wrong.
In this case, the police had a search warrant for room 123A to find Adderall and marijuana. However, they knew that there was a separate residence, 123B, and administered a search anyways.
How were these 2 residences separated that made them separate and distinct?
They had separate addresses, numbers, well, different letter at the end of their number.
Were they part of the same structure?
They were in the same structure, however, they were each individually separated. So the acts going into 123B, having knowledge that it was a separate residence, was flagrant and unreasonable.
But couldn't there be other circumstances that would justify a search of the room?
Your Honor, in one's castle, there is a subjective expectation of privacy that society will view as objective. And in this case, the officers should have conducted a warrant to follow procedures and protocol.
Isn't there a plain view doctrine that's acceptable here where the officers saw the butt of a firearm?
Yes, and I'm not here to argue that seeing the butt of a gun did not allow them to enter the room. However, the total search of 123B is unjustified within its scope because they continued after finding that the butt was a replica.
Counsel, I thought there was a warrant to search the whole apartment. I mean, I heard you say that 123B is a separate entity, but we're dealing with a 2-bedroom, 1-bath apartment with the door open. How could the police know that it's separate, need a separate warrant whenever they have a warrant for the apartment?
Your Honor, the facts, their warrant was addressed to 123A.
But how many apartments have 2 addresses in the same exact unit?
Many do, and since this is a college issue, many college dorms have sub-duplexes with different residential numbers. There was also a lack of consent, and there was an authority to give consent as well. By valid consent, an individual may legitimize police conduct that would otherwise violate the Fourth Amendment.
Where is there an issue of consent? Was consent specifically given by one person or another?
No, there wasn't. There wasn't even authority
So
to give.
consent's not actually an issue. We don't really have to deal with consent because there was none, correct?
Yes.
Okay.
In Maryland v. Garrison, officers had a search warrant for an apartment, and after searching 2 rooms that had open doors, they found paraphernalia and then immediately gained knowledge that it was a separate apartment in the duplex. They immediately stopped their search. And here, although the police mistake was objective and reasonable and understandable, but in our case, the officers had prior knowledge that the apartments had 2 distinct addresses.
Could there be another reason to conduct the search? Like maybe they were conducting a limited sweep of the premises to determine whether or not there's a threat?
A threat to where?
To officer safety.
The proper protocol would have been if there was a threat, the petitioner was not present in the apartment, there were several officers conducting the search warrant in the first apartment, and proper protocol could have been, for example, leaving one on the premises while the other went to execute a search warrant and come back to continue their search.
Counsel,
Yes.
your client leaving the door open, didn't he give up his right to privacy?
No, sir.
Did he have standing at that time
Standing as to what?
into the apartment?
It is considered his castle, so he had his expectation of privacy.
But if it's a college dorm room, I think what this justice is saying, it's a college dorm room, there's a common area, and he knows it's a common area, and he leaves his door open. So isn't he kind of saying to the rest of the world, hey, I don't really have anything to hide, that's why I left my door open. So doesn't that diminish the expectation of privacy?
I see my time's up. May I answer your question and conclude? I think that leaving the door open does not allow the police to go into the room in any lesser way. They should have obtained a warrant to enter the room and conduct a search. And for those reasons, we ask this court to reverse the Supreme Court of Police decision and reinstate the trial court's decision that a warrantless search violated the Fourth Amendment rights to be free of unreasonable search and seizure.
May it please the court. My name is Brianna Washington, and I will be answering the question of whether the search of the box violated the petitioner's Fourth Amendment rights. First, the search should have been terminated at the discovery of no weapon. Second, there was a lack of probable cause. And third, from a policy standpoint, the exclusionary rule should be applied. For these reasons, we ask this court to reverse the Supreme Court of Police decision and reinstate the trial court's decision that the officer needed a warrant to search the petitioner's bedroom. The search should have been.
Counsel, I thought there was a warrant to cover the apartment is supposed to be for pot and for Adderall. Now, I realize the petitioner couldn't himself fit inside the box, so that wouldn't be included in the protective suite, but isn't there already a warrant to look within the apartment, like in the items within the room?
Yes, Your Honor, the warrant was specific to 123A, and Connor Quickdraw was specifically to 123B.
I asked your co-counsel this earlier, but how, like, the answer to how the police were supposed to know is because it's a college dorm room and it's somewhat common. That's the answer for how they knew that it was different.
No, Your Honor, the police knew prior to arriving to the residence that there were two separate distinct addresses that would have required a separate warrant to search 123B.
So they're allowed to go into the room to conduct a limited protective sweep, is that right?
Well, there was not a search incident to arrest that would have allowed a protective sweep, so.
You don't need a search incident to arrest to conduct a protective sweep. You conduct a protective sweep for officer safety, and they saw a gun, right?
What they thought they saw was a gun, correct?
So would they be allowed to investigate that?
They would be allowed to investigate that after seeing that, and then after realizing that the gun was only a replica, there was no danger that was further imposed, so the search should have terminated there.
I'd like to ask about inevitable discovery. So let's say the officer saw this gun handle, and he said, you know what, there's contraband, we're gonna need a warrant. They get this search warrant to search the property, and they're gonna find it anyways, next to the gun box, isn't that correct? So wouldn't that apply here?
That would have applied here, but Your Honor, those facts did not occur here. The gun was indeed a replica, there was no danger posed to them that would have led to a warrant, needing a warrant for the petitioner to search the petitioner.
Was the warrant complete when the officers had found the marijuana and Adderall? To what extent did that warrant give the officers then?
The officers were continuing their search into the common areas, which very well could have had additional substances that could have gone with the warrant. So they were valid in searching the common areas because the warrant said the 123A apartment, and a part of the 123A apartment is the common areas. However, the 123B is not a part of the 123A apartment.
Here's my problem. Excuse me, but I I'm looking at, can we agree that at the moment the police officers entered into your client's room, it's not really an apartment, it's a room, okay, it's part of an apartment, that they were lawfully placed?
Yes, Your Honor.
Okay. Were they engaged in lawful activity?
Yes, Your Honor.
And they observe a box with some pornography in it that would appear to be child pornography. Is the evidence that they're looking at, its criminality readily apparent?
Your Honor, the facts did not indicate whether they had to manipulate the box or not, so if the officers would have opened the box, then that would have gone beyond the scope of looking to see if the weapon was real. However, under Kentucky versus King, an officer cannot create unreasonable exigent circumstances to conduct unconstitutional behavior in order to qualify under the Fourth Amendment.
But it says, the facts as I understand it is that later they were able to identify it as not being a firearm, but a wooden replica at some point, okay? There was more than one officer in there from what I'm aware of. Is it not possible to argue, and doesn't the state have the right to argue, that this pornography that was sitting in a box, which we're unsure if it was open or closed, let's assume for the purposes of this argument it was open, and they could look down and see the pictures, that in fact its criminality was readily apparent, so therefore does it not fit the classic plain view doctrine?
Yes, Your Honor, but however, those facts do not indicate that whether the box was open or not, so the petitioner cannot, the petitioner's rights would be violated because we don't know if the box was open. If the box was closed, the petitioner's Fourth Amendment rights were violated. And from a policy standpoint, the Fourth Amendment was created, the exclusionary rule was created to deter police misconduct and to protect the privacy of the individuals. And past looking at the wooden replica, there was no danger that was posed to the officer, so the search should have terminated. If they wanted to go get a warrant, one of them could have stayed to prevent destroying the evidence.
So you would agree that they could have gotten a search warrant, is that correct?
If the box was open.
If the box was open, but they could, okay, so if the box was open and they could have got a search warrant, they would have, inevitably, they would have discovered it, correct?
Right, and we don't know whether the box was open or not, and they also did not go and obtain a search warrant.
If the box was closed, they could still get a search warrant, couldn't they?
There's no facts that indicate that they would have a probable cause to get a search warrant.
What about the search for more drugs? You found drugs throughout the apartment already. Why couldn't you look for more drugs?
Well, they already knew that they were separate, distinct addresses, so if they wanted to go ahead and search the whole premises, they should have gotten a warrant to do that.
But are you conceding that they could have gotten a warrant to do that?
Not necessarily, because the informant was about is it okay if I finish the answer and then conclude?
Yes.
If they would have, if the informant's information included Connor Quickdraw as well, then that would have validated the search warrant provided by a dependent magistrate, but in this case, that was not the case. For these reasons, we ask this court to reverse the Supreme Court of Police decision and reinstate the trial court's decision that the warrantless search violated the Fourth Amendment right to be free of unreasonable searches and seizures. Thank you.
Good afternoon, Chief Justice, Associate Justices. If it pleases the court, my name is Susan Lee. I and my co-counsel, Kimberly Lewis, will be representing the respondents in this case, the state of Cooley. I will be addressing the issue of whether the search of 123B Tampa Lane was justified by newfound suspicion. Your Honors, the search of 123B was justified by newfound.
What was the newfound suspicion?
Newfound suspicion, Your Honor, was the butt of a rifle protruding from under the
And
bed.
did the officers find that it was not a buttable rifle, it was just a wooden handle?
Ultimately, yes, they did, Your
So
Honor.
at that point, shouldn't the search have ended?
Based on, the plain view doctrine, Your Honor, the viewing the buttstock of the rifle protruding from underneath the bed, allowed them to investigate further. When they looked under the bed to investigate further, they found the box that contained pornography. This allowed them probable cause to do a
Wait,
search.
wait. You said when they saw and determined that it was not a firearm, that they investigated further?
They found the box next to the
Okay,
gun.
I'm trying to figure out how did they find the box? You just said that they investigated further.
After, when they went into the room to investigate what they thought was the butt of a rifle, they found the box next to the rifle.
Counsel, isn't after they realized that the gun was fake, the protective sweep is over, correct? Shouldn't it be over?
Not if they find, evidence of further criminality.
I know, but
You're fine.
I was gonna say, but a fake gun isn't criminal. He can't have a real one because he's a felon, so he has to have a toy one to stay happy. What's wrong with this, with him having a toy gun?
Well, there's nothing wrong with him having a wooden replica, Your Honor. However,
So why do you go into the box once you determine that the gun is fake and that there's no one hiding under the bed? Why do you go into the box for a protective sweep?
I'm so sorry, could you repeat your question?
Okay, so you enter the room because you're concerned about officer safety in order to conduct a protective sweep in case, there's someone hiding underneath the bed with a gun, because you see the gun. So you go under there, you find the gun, turns out it's fake, turns out there's no one under the bed. Why do you go into the box? Because it seems your protective sweep has ended once you determine that there's no real danger.
That's very true, Your Honor. However, when they bent down to investigate to the gun, the box was right there, and they saw the photographs of child pornography.
Counsel, I thought the facts didn't say that the facts never stated whether or not the box was even open. All we know from the record is that they found the box by itself.
That's true, Your Honor. However, upon entering the room and finding a box, that box could contain another weapon. He is a known felon, just because.
What was I'm sorry. What was illegal? What was illegal about the gun being in the room underneath the bed? Because he wasn't in the room. So he's a felon, correct? But he didn't have the gun. He wasn't in possession of the gun, so what law was he breaking at that point?
As a felon, he's not allowed to have a gun.
Right, but he didn't have a gun.
Well,
Because he wasn't even there.
He wasn't there, Your Honor. However, there could be other weapons in the room. And in finding that box next to that would.
Does that mean that anyone that's a felon, you can go into their room and look for guns everywhere? Because there could be a gun in the closet. There could be a gun under the bed. There could be a gun under the blanket. Should the police have that unlimited amount to search everywhere? Because any felon can have a gun.
That's true, Your Honor, but not necessarily. However, in this case, when they were on the premises under a lawful valid warrant, and they stepped out into a common area, and they saw.
Counselor, their warrant was for room 123A, correct?
That's correct, Your Honor.
Why didn't they just secure the premises and order a warrant for 123B then? Shouldn't they have done that instead, just going into the room and searching?
Well, if you take the totality of the circumstances, Your Honor, when they stepped out into that common area and they saw the door was open just a little bit, there is the probability that there could be someone standing behind the door. They needed to get into that room. When they saw the butt of that gun protruding from underneath the bed, that gave them probable cause to do a protective sweep. Yes, Your Honor?
I have a question. Did it have anything to do with entry into that room? Did it have anything to do with the police knowing that he was a felon? Because if he wasn't a felon, would they still would have entered into that room?
I believe with experienced officers, yes, they would have entered that room, Your Honor. Because they were searching, because they were on the premises with a valid warrant, searching for marijuana and Adderall.
Was this a hunch? Because it clearly states in the fact, police knowing Connor Quickdraw to be a felon opened the door to investigate the weapon. Did that have anything to do with their decision to go in that room, the fact that he had a criminal past?
It may have, absolutely. If he's a felon and if they know he's a felon.
So he doesn't have
and they
Fourth Amendment
see-
rights?
He does have Fourth Amendment rights, Your Honor. However, with plain view, they were lawfully on the premises. They have legal.
Do we look at the subjective intents of the police officer, or do we look at their actions and see whether or not they're objectively reasonable?
We would look at their actions to see if they're objectively reasonable.
Where-
And that brings up a good point, Your Honor. In CATS, there's a two-pronged test for privacy. There's a subjective and objective. And in a home, obviously, the expectation of privacy has a higher threshold. However, one must exhibit the desire for privacy, closing your blinds, closing your doors,
Hiding a box under your bed?
potentially.
I want to ask you about, okay, so you're arguing plain view now, right? And then you're arguing, well, it was a cursory search. So which is it? Was it because of plain view doctrine that you entered, or was it because of a cursory search?
It would be plain view, Your Honor.
It would be plain view?
Plain view. It was in his view, they were in, rightfully,
He was there?
he was
They were
there from
lawfully
their
there?
vantage point, he was there lawfully under the plain view. I see my time is up, Your Honors, may I briefly conclude?
You may.
Thank you. For the points that we've talked about today, we would request that this court, affirm the state Supreme Court's ruling that a warrant was not needed because probable cause did exist to search 123B Tampa Lane. Thank you very much.
Thank you, Your Honor. Thank you, Chief Justice and Associate Justices. My name is Kimberly Lewis, and I, along with Susan Lee, will be representing the state fully in this matter. I'll be addressing the issue of whether the box under the bed violated the petitioner's privacy interest under the Fourth Amendment. I have 2 points, Your Honors. The first one is that the officers were permitted to search the box based on a lack of reasonable expectation of privacy. Second, the officer had probable cause to search the box based on a finding.
Why did he lack a reasonable expectation of privacy in his own bed?
Because he left the door open, Your Honor. What we have is the two-pronged CATS test.
Well, what if we thought that in like a hotel, right? So if I have a warrant, to search a common area of a hotel, and a guest leaves their door open, can the police go into that room?
What happens here in this case is there's definitely not a reasonable expectation of privacy if you leave the door open. If the police will be able to go into that room if they have probable cause to enter that room under a plain view situation.
Counsel, petitioners think that they argued that there's 2 separate addresses and that the facts indicate that the police were aware of this, and that the facts also say that they realized that the gun wasn't real, and the protective sweep was over. I think that we're just running in circles. Why did it not just end right there?
Well, I respectfully, sir, may disagree with you on a few of those points. I don't know if the protective sweep was actually over. I don't.
Why?
It was over as soon as they stepped in the room and there was no person in the room.
Well, the
gun couldn't shoot itself.
issue was the protective sweep. We have a closet to look into potentially.
So why didn't you look in the closet?
I think they didn't look in the closet because as soon as they recognized the gun underneath the bed, they also saw immediately contraband in the form of child pornography right there. Therefore, we have a probable cause. We are right there looking at a crime. We're looking at contraband right here. It's next to the gun, even though it's under the bed, so is the gun under the bed, except for the little bit of the stock of the barrel.
So would you agree that the protective sweep portion was at least over once they found that there was no one under the bed and no one had access to the gun?
I would assert that the protective sweep was over as soon as they saw the pornographic material
What
and saw no one under the bed.
pornographic material makes the officers fear for their safety?
I don't think at that moment the fear was for the safety. What I believe is.
Then what would be the purpose of the protective sweep if it's not for their safety?
Well, there was a purpose for the protective sweep, and it ended when they realized they're looking under the bed, as you stated, they didn't have a person hiding under the bed. But in plain view, while they're looking under the bed.
Problem.
Yes, sir.
What does it have to do with the person being under the bed? I don't understand how the protective sweep ends when there's no one under the bed. Is it, did we require that someone actually be where the gun was? I thought the gun and weed was found inside of a washing machine, if I'm not incorrect.
It
With
wasn't.
no person inside the washing machine, so what does that have to do with the price of tea in China?
Your Honor, I was just caveating off of Associate Justice's comment, but you're correct. It doesn't, hence why they could have looked in the closet, they chose not to, according to the facts that we have. But I think once the child pornography was found, it took on a completely different feel.
So your position is that the whole case changes based upon seeing a box with pictures in it?
I say that the case changes because what we have here is we have discovery of child pornography, which we clearly know is.
But I come back to the same question, and multiple of my brethren up here and sisters, or sister, has been questioning. And that basically is at the point that they saw that there was a box with child pornography on it, setting aside any possibility that there might have been plain view, the question I come into is why didn't the police then secure the premises and go get a search warrant for something that was outside the scope of the initial search?
Your Honor, in Coolidge v. New Hampshire, which is the beginning case, it's basically an example of the applicability of the plain view doctrine. In the situation which the police have a warrant to search a given area for specified objects, in the course of the search, they come across some article of incriminating evidence. And moving forward to a closer case, in 1990, was Horton v. California, which this esteemed court actually ruled on it, and that goes to under the plain view doctrine. The police may seize an item, and if its incriminating character is immediately apparent. I say to you, Your Honors, that the incriminating character was immediately apparent.
Well, since you're pulling cases out, how about Segura? Why is it that when they entered the apartment in Segura and they saw something in plain view, why did they have to wait 19 hours to get a search warrant?
Well, we could also talk about the Illinois case where they found the stereo equipment.
That's it. You know, we already know Hicks. Okay, that's Hicks. I got no problem with Hicks. That spells out what plain view is. What I'm trying to understand is, on the basis that you're arguing now, it would seem to me that Segura was wrongfully decided because at least at that point they didn't need 19 hours to go get a search warrant. They might have wanted to just grab everything when they walked in the door. It was in plain view. Everybody knows it was cocaine. Everybody knows that it was money. Everybody knows it was a 3-beam scale. So why not just grab it right there and then?
Well,
and the guns, by the way, I forgot to mention.
Right. Sir, under the totality of the circumstances, they're doing what they're doing is actually the gentleman walked in while they were actually inventorying the pictures. So under the totality.
What does that have to do with the propriety of finding the pictures in the first place?
Well,
if I go into my house and the police are searching and they find a gun and I walk in while they're searching, but they don't have a warrant to search, what does that have to do with whether my Fourth Amendment rights were violated? Because now I'm there, so it doesn't violate my rights?
Because under plain view, Your Honor, we have an exception to the warrant. It allows us to seize property that is contraband.
Well, is plain view dependent upon the defendant walking in the door?
Your Honor, may I finish answering the question?
Well, you ask him, not me.
And may I continue? Thank you, Your Honor. Your Honor, it is not necessarily dependent upon the defendant walking in the door. But in this circumstances, we have an egregious violation of a societal wrong, which is child pornography.
Is this the child pornography exception to the Fourth Amendment?
This is not the child pornography exception to the Fourth Amendment, but in Osborne v. Ohio, Your Honor, they did rule, which is also this court in 1990. They talked about the legislative judgment as well as the judgment found on relevant literature. Even though it's not a First Amendment issue per se, we can't shout crowd in a fire crowd room, we can't shout bomb on a plane. You also can't possess child pornography. Thank you, Your Honors. For these reasons, we ask the court to affirm the state Supreme Court's decision, affirming the Intermediate Appellate Court's opinion that a warrant was not needed because suspicion of probable cause existed. Thank you.
Thank you.
Your Honors, we're asking this court to reverse the Supreme Court's decision. Like Chief Justice Mitri said, if there appeared to be found child pornography, the respondents should have secured the premises and obtained a valid warrant. When the plaintiff came back, they were already cataloging the evidence. In Coolidge versus New Hampshire, as my opposing counsel stated, the Supreme Court ruled that you cannot use the plain view doctrine as a safeguard to place searches under the Fourth Amendment. This would be an issue with public policy, and would that allow police conduct to continue going into felons' rooms just to see if they have a gun?
Counsel, the respondents are saying that once they found the gun sticking out, they looked under the bed and it was sitting right there wide open. That this isn't an exception to plain view, this is absolute plain view, like the doctrine in its entirety. What's your argument to that, if what they're saying is factually true?
I believe that once they saw that the gun was a replica, the search should have immediately stopped. However,
So based on public policy, if they see a box of child pornography, oh well, can't search me.
I'm saying under public policy, not obtaining a valid search warrant, if this is ruled in favor of the respondent, would it allow further police conduct to continue conducting searches without valid search warrants? And under Ibarez, the mere proximity of a search warrant, such as 123A, does not give rise to a search to anyone in the mere proximity. For these reasons, we ask this court to reverse the Supreme Court's decision and reinstate the trial court's decision. Thank you.
Thank you.
All right, court is now in recess with all advocates and observers